Thank you, Mr. Chairman. Thank you and Senator Blumenthal for holding this hearing and focusing a light on this issue. It's an issue that's important to our country and something that Congress has been trying to fix for over a decade, and hopefully this will be the year when we finally find the path forward that enables us to put in place a workable solution that protects consumers and addresses this very important issue, which again we're reading about today. Millions of Americans impacted by yet another data breach. I want to ask, and Senator Blunt mentioned this because I think the question's been asked many times, but perhaps not everyone has answered it. But Ms. Weinman, I'm just curious because you have extensive experience in this area, having worked at the FTC prior to your current position with ITI. Could you give us your sort of explanation why you think a single federal law is so preferable for both businesses and consumers?
Thank you. I have a chart with me that's 19 pages long that goes through the variances of the different state laws. That reason alone, I think, lends itself to having one federal breach notification standard to enable companies to act quickly and provide the required notice. So I think it's both business-friendly, but more importantly, consumer-friendly.
Mr. Duncan, your testimony today highlighted the need for Congress to enact a preemptive federal data breach notification law, and I agree that doing so would provide a great deal of clarity for companies, including the retailers and merchants that you count as your members, but it also would provide needed consistency, I think, for consumers, which, and that's an issue that, as I said before, Congress has dealt with in the past. There have been various legislative proposals that have called not only for uniform notification procedures, but also for uniform federal data security standards. And I appreciate your observations about some of the risks of FTC enforcement, but since that enforcement can already occur, wouldn't retailers benefit from a federal law saying that reasonable data security measures must take into account the size and scope of the organization and the sensitivity of the data collected?
Thank you, Senator Thune. The FTC effectively has a reasonableness standard, either under deception or under unfairness right now. Once you begin putting a lot of different factors into that standard, then you essentially set up a situation where was it reasonable as to A, as to B, as to C, as to D, and if a medium-sized company can't check the box on every single one of those factors, then they're likely to be in very bad shape. That kind of standard works better when you're developing guidance. And that's a big distinction between the GLB standards that Mr. Johnson has talked about and a uniform national standard. If you've got an examiner sitting next to you and you can, so as an iterative process, work through each of those various elements, that may work. But if you're trying to set one standard for every type of commerce and every type of business in the country, then having multiple components to that is going to make it impossible with any certainty for the average American company to respond to.
So could NRF support any type security requirement?
Sure, if there's a standard comparable to that the FTC is currently enforcing, which is a reasonable security standards, and if that's coupled with the very, very robust notice requirements that we've testified in favor of, that would work.
Okay. I have a question for Attorney General Madigan. Ms. McGuire in her testimony suggests that any notification standard should minimize notifying individuals about breaches in which their personal information was rendered unusable before it was stolen. Ms. Weinman suggests that the exposure of unreadable data will not result in risk, therefore notice would not be appropriate. And I'm wondering kind of what your thoughts are on the wisdom of including a usability reference in breach notice legislation, and then perhaps how the Illinois state law approaches that issue.
It's the right thing to do. I agree with both of them on that front. In Illinois' law, if the information is encrypted, you don't get notification of the breach. What we need to look to, because we've seen this in some of the breaches taking place, is encrypted information has been compromised and the encryption key has also been stolen. In those circumstances, when you can unencrypt, then there should be notice. But if it's encrypted, if it's unusable, unreadable, notification does not need to take place under Illinois law.
Okay, great. Mr. Chairman, thank you.
Mr. Chairman, thank you.